All the second stage tanks now pressurized. Astronauts report it feels good. T-minus 15 seconds. Guidance is internal. 12, 11, 10, 9. Ignition sequence start. 6, 5, 4, 3, 2, 1.
Torpedo to the jugular. This is Honey Badger Radio. Radio with Buddy.
Feminists say that their ideology is all about equality of the sexes, but the movement's real-world activism doesn't support that. HBR Talk with Hannah Wallen. I've been watching feminist activists claw and tear at due process rights for 30 years. That fight has been gendered. They've worked very hard to limit the damage they've done to only instances where men face accusations of intimate partner or sexual violence against women. I've listened to them support these attacks by demonizing men as violent sexual predators. I've watched feminist researchers use deliberate bias in their work to manufacture statistics to support that demonization. I've watched them lobby into place changes in law and policy that force men accused of intimate partner and sexual violence to fight a guilty until proven innocent standard, then limit what exculpatory evidence they can present, and protect accusers against repercussions should they be caught using lies to try to obtain a conviction. It cannot be rationally argued that lobbying for laws to impose accountability on one sex while exempting the other from accountability is an effort to achieve equality of the sexes. It can't even be argued that it's about fairness, because the changes feminists fought for are designed to increase convictions of accused men regardless of actual guilt, while protecting female accusers regardless of whether their accusations are valid or criminally false. They advocated for the legal imposition of a double standard. It is by definition an attack on fairness and equality, in which they've demanded men's civil rights be infringed for women's purported benefit. But as reprehensible as that is, its implications are even worse. The civil right of due process isn't just about fairness. Fairness is important in a court of law, and it's part of what legal due process standards are created to uphold, but the civil right itself is actually a protection against government abuse of the otherwise powerless individual citizen. If an authoritarian ideology wanted to completely take over, dominate, and control the United States of America, civil rights protecting citizen dissidents against government retaliation create a solid, insurmountable barrier against their efforts. The most obvious is freedom of political speech, another civil right we've seen feminists attack. An authoritarian government cannot allow that freedom because it allows the citizen to challenge the actions and authority of governing bodies. This is why nations with totalitarian theocracies or dictatorships are so heavily censored. Censorship isn't the only way totalitarian governments smash dissidents, however. Another means is wrongful criminal conviction and imprisonment. Without things like the innocent until proven guilty standard, the right to present evidence in your own defense, the right to confront your accuser in a court of law, the right to legal representation and legal recourse if one's accuser lies in court, the dissident citizen would be vulnerable to punishment or at least silencing via false imprisonment based on trumped-up charges. Feminists are breaking down that protection against government abuse of power, one detail at a time, using society's protective attitude toward women as the wedge to destabilize the civil rights structure. That isn't going to work out the way they present it, as a protection for women. Eventually, somewhere in the country, the fact that our society has condoned infringement of those rights in cases where men are accused of intimate partner and sexual violence will be used as an argument in court supporting infringements of those same rights in other cases. And if there's case law upholding those infringements, they'll be extended to whatever criminal allegation the prosecutor is attempting to prove. Imagine being told that you cannot present your purchase receipt for a disputed item as evidence against a theft charge because you're just trying to use it to shame and humiliate the store owner. But are feminists aware of the groundwork they're laying? I think the academic and political leadership probably knows, but the grassroots has no idea. They are trapped within the victim identity cult formed by the leaders and dogma creators within their movement, and they're going to view everything through that filter. One I explained in a recent blog post on how social justice NPCs are created. It started with feminists gendering the concept of oppression, deeming women a victim sex whose advantages don't count and whose adverse experiences are always the result of prejudice and discrimination. They've deemed men the perpetrator sex whose advantages are always the result of prejudice and discrimination and whose adverse experiences never are. They portray physically surviving one's own emotional fragility as a sign of feminine strength, and they push for men to be identified as always having power over women. That female frame makes the victim identity a female power identity, prompting the victim's female grassroots to adopt it. The male frame's more blatant power identity creates a guilt trip and then provides male feminists with two escape clauses from it. They're either bad power, or perp in need of feminism's control, or good power, the protector identity. When these identities are adopted wholesale, the identitarian will see any evidence against them as a threat of self-erasure. Within their respective identities, feminism's grassroots are now primed to object to any failure to favor any woman's interests any time they're in conflict with those of a man. Suddenly, failure to discriminate is now discrimination, at least if the person facing discrimination is male and it's for the benefit of a female. You now have a politically active portion of one sex willing to accept blatant harmful violation of their human rights and personal freedoms for the perceived benefit of the other, which is willing to demand those violations out of a sense of disenfranchisement-based entitlement, in other words, as a form of reparations. When a female student makes an accusation of sexual misconduct, she's not just seeking justice. She is presenting her identity for validation by the staff responsible for handling her complaint. To put it more bluntly, she's there to get her victim card stamped. That's not to say that she's not a victim, but that regardless of whether she is or not, that validation is expected. This is why we are seeing college co-eds accusing Betsy DeVos of supporting rapists and throwing victims under the bus. Not because there's any evidence the changes she has proposed will lead to the violent sexual chaos on university campuses they are predicting, but because it's not important to them whether the incidents of alleged misconduct are real or not. They are unable to recognize the difference, and they are unable to recognize the rights infringements the existing policy has caused against male students by supporting fake cases with fake standards. The perpetrator sex doesn't have rights. The victim sex has rights. The perpetrator sex has obligations, and one of those obligations is for one of its number to become the scapegoat any time a member of the victim sex needs one. I expect glorious tantrums from university feminists and their academic and political leaders if any of the proposed changes become official. What will be really interesting, though, will be to see further down the line as the dire predictions don't come true. Perhaps this experience could affect some students differently. Cognitive dissonance can shatter biases like they're made of glass. Maybe it'll lead to the next generation's Janice Fiamingo or Christina Hoff Sommers, or even another with the political X-ray vision of Alison. I'm not going to hold my breath, but one can always hope. When my friend Roger's ex-wife stabbed his niece's dog, family court finally issued a restraining order against her, but police refused to enforce it. Roger's ex-wife filed blatantly false charges, got caught lying to police, perjured herself, and even stalked him and his witnesses, all while a biased court turned a blind eye. It took myself and a whole team of his other friends working together around the clock to protect him from further false accusations and to put a stop to her abuse. Roger wasn't the first male friend I'd had who experienced a court system slanted against men. Jason was convicted of assault strictly because his ex said she was scared of him. Mark because a judge thought stopping a woman from stabbing him in the throat was abusive. Steve spent a weekend in jail for non-payment of child support because of a caseworker's typo. My friend Roger wasn't a wake-up call for me. He was the last straw. Witnessing false accusations against friends in multiple jurisdictions in multiple counties made it obvious that this was an area of systematic, institutionalized discrimination against men, one that blindsides them all too often, with life-wrecking force. I learned the importance of documentation, of seeing through and exposing false framing and other forms of deceit, and countering victim narratives used to disguise glaring fabrications as legitimate complaints. I sought out men's rights forums to share the tools I had seen work against false accusations, and soon realized that the false accusations I witnessed are a symptom of a larger, broader pattern of lies. Men stand wrongly accused of the ill-defined crimes of patriarchy, of privilege, and of toxicity. Spurious, distorted narratives created in women's name are used to push for a corrupt system that, intentionally or not, helps liars destroy men by stripping all men of a presumption of innocence. I want to provide you, our listeners, with the tools to fight back against those distorted narratives and the abuses they are used to support. I want to arm men against the lies used to dehumanize and demonize them. Most of all, I want men to be able to assert their own truth, without fear that it will be buried under the rubble of society-wide false accusations. Ask yourself if that's something you'd like to see more of. Ask yourself if you'd like to support my efforts in arming fighters. And if your answer is yes, please go to www.feedthebadger.com. Thank you. Hello and welcome to HBR Talk 62, Title IX Update. Badgers discuss Betsy DeVos's proposed policy changes. I'm your host, Hannah Wallen, here with that adorable specter of death, Prim Reaper, and our undercover badger, Andrew, to take a look at Betsy DeVos's proposed changes to the Education Department policy on campus sexual misconduct allegations as part of Title IX. That sounds like a mouthful, doesn't it? Maybe I should file a complaint. But first, here's a little education. As you know, the social media gulag is ever expanding, which is one reason why we've diversified to multiple platforms: YouTube, Facebook, Twitch, and audio-only formats. The Badgers, we are everywhere. So if you want to be able to keep track of it all, remember to go to badgerfeed.com and register to receive notifications. After all, with all of those non-shadow bans, you need notifications from badgerfeed.com to tell you what we're doing and when. And if you're still listening to our live streams on the main Honey Badger radio channel, please, that's old news. For live streams, the Badger Live Streams channel is where it's at. Last but not least, don't forget to like and share this and other Honey Badger live streams so they'll have more social media visibility. The solution to social media throttling is to use 1,000 whispers to reach every ear that's been closed off from one muffled shout. That's our end of the balance of power. Either we use it or we lose it. And speaking of balance of power, let's take a look at those policy changes.
So a few months ago, somebody got a hold of the leaked proposals, and not much has changed since then. Overall, they're mostly good. There's one area of concern with regards to double jeopardy, but quick overview and the list, and then we can talk about each point. Schools have to provide live hearings. They can't do single investigator models anymore, basically. It gets rid of that. Cross-examinations must be allowed. However, it won't be the students cross-examining each other. It'll be the advisor for each student being allowed to do the cross-examination. Schools have to actually give students information, so when they inform them that a complaint has been filed against them, they actually have to say, like, give details so the student can defend themselves.
Wow, novel idea.
They can't be, like, ambiguous saying, hey, we received a complaint against you, and that's basically it, because schools have done that in the past, where they just say, you've been accused of sexual misconduct, and they don't even give the date. Like, that has happened.
Yeah, that's
schools can use the preponderance of evidence standard only if that's the standard that's basically used throughout all misconduct or hearings that the school would have, and that also applies to faculty administrative proceedings. That's a really important bit, and I think we'll talk a lot about that. Fire previously found that a lot of schools actually don't specifically presume innocence in their policies of the respondent. So schools have to actually, assume that the person who's defending themselves, the respondent, is actually innocent until proven guilty. Oh no. That the definition of harassment has been much more narrowly defined, which is very good, because before it was too broad. Schools are a lot less, will get less in trouble in terms of they can't be held responsible for something that they didn't know about. So only officials that have actually been told that of a complaint can actually do anything. A lot of these schools have basically, if a faculty person finds out that a student has been sexually assaulted, they have to mandatorily, I don't know if that's a word, they are required to report the misconduct. They can't basically be a person that can confide in the student. And then the negative part that we found was that complainants and respondents can appeal a ruling. It would be good if the respondent could appeal the ruling. That's good, but the complainant being able to appeal the responding is like, okay, well, you didn't do it right the first time, so
it subjects the respondent to
it's
double jeopardy.
It's really screwbally, and a lot of problems with recent cases has been in the appeals process, where there's just been a ton of problems, from conflicts of interest to new evidence being introduced out of the blue, apparently.
Oh God.
So,
well, there's also the issue of students that appeal when they don't get somebody found responsible, and they come back with lawyers and threaten to sue the school if they don't get the result they want. And then the school changes its mind. The administrators change their mind, not based on the effort, but based on the fear of the lawsuit. So that's one that if they're going to do that, then they're going to have to exempt schools from the repercussions of finding a student not responsible. They're going to have to say they can't be sued for that. If they're going to allow for that double jeopardy. But they really shouldn't allow for that double jeopardy to begin with.
No,
yeah, let's just say that next June, it's going to be very interesting when I go back to that conference.
Yeah, I know. I can't wait to hear the way they're going to talk about these proposed regulations, considering what we heard from the last one.
Well, yeah, especially the keynote and even the presentations will be very, very interesting, because by then, the regulation will have been put in place if it passes all that stuff and doesn't change too much, which I don't expect it to change all that much, honestly.
Well, the way this goes is she submits these to Congress, and Congress has, if I remember right, if I understand things correctly, they have 60 days. If 60 days go by without any acting on it by Congress, then it passes. Congress actually has to say no in order for it to not go through. So, how long ago did this come out?
I think it was last week or week before. Okay. It might be butting up on when the Democrats actually have control of the House.
Yeah, but they actually, I think this has to go through, I don't remember whether it's the House or the Senate. I'm pretty sure it's the House. So they would have to vote it down for it within that time period. And if they are just starting up, unless they're paying attention to this and focused on it, they're not going to do that. With them being distracted basically by Trump, and all of what's going on with the accusations against Trump and everything, they may not. They may let this go through.
Especially because they might be worried more about impeaching him or trying to find out who the new speaker is, but that's a whole different problem.
Yeah. I know one thing. I do recommend, anybody that's listening that's in the United States, find out who your senators and congressmen are, and write to them about this and how important it is to preserve due process in this instance rather than attacking it, continuing to attack it, because this is something that if this goes through, if these protections go through, it'll be a step in the right direction toward legal reform. And if they don't go through, it will be a huge blow to legal reform, because if they're not going to reform the campus court system, they're definitely not going to reform the real legal system.
Yeah.
One of the points I forgot to include in this write-up, now that I'm thinking back on it, previously the Obama administration, with their 2011 Dear Colleague letter, they said that schools can't offer informal resolutions, so basically mediation as an option. So nothing really shows up on a student's record or anything. That was done away with in 2011, but that's being added back in as an option. I think both students have to want to go through with it that way, so it'll be curious to see how much it's actually used if some of the complainants are want to see a formal hearing and stuff. But it'll be that particular one pissed a lot of people off on the internet.
It's kind of dumb. They
actually, I mean, all these things pissed people off on the internet, but that one in particular, there was a lawsuit over it, where
the idea that
where the school had tried to do an informal resolution, and then the student came back and sued.
Oh,
I think is suing because the 2011 illegal that didn't pass properly through all the channels. The Obama administration worked that one up. Basically said, yeah, no, you can't do informal resolutions. It has to be all through adjudication.
And see, the reason there should be informal resolutions is because there are times when women, after an engagement with somebody, whether it's a sex act or they've had a conversation and somebody has said something that they've taken offense at, a lot of times they're not necessarily feeling victimized, but they feel like they've been mistreated. And there's a big difference between feeling mistreated and feeling victimized. Somebody can mistreat you accidentally because they're a clod, or you can misinterpret somebody and feel mistreated when in all actuality they didn't actually do the thing that you think they did. You just took it that way.
Even in that case, being mistreated is not illegal in most cases.
But the thing is,
people are allowed to be dicks.
Right.
Yeah.
The thing is, with informal mediation, if somebody's not 100% sure, if somebody's sitting there going, I don't like the feel of this and I'm upset about it, but I don't want to make a, to use a slang term, but I don't want to make a federal,
this guy's life.
Yeah, I don't want to make a federal case of it. I just want to have a talk about it because this was really rotten. That gives them the ability to address it without, trying to destroy the guy's life. And so there will be two good things that'll come out of this. The first one being that anything that just barely passes the threshold, but isn't really something that if it was malicious should necessarily destroy the guy's life, they'll be able to deal with it in that mediation. And then anything that doesn't pass that threshold of, I'm willing to seek a formal hearing for this, but should be addressed, won't go under the radar because they can seek informal mediation for it. So it's that keeping that down, keeping that unavailable, ends up silencing people instead of actually protecting them.
So, do we want to go down the list?
Yeah, let's start with the first one.
So, schools must provide a live hearing. Basically, in the past, schools could do a single investigator model where the person would just investigate and adjudicate, or basically that. And through various meetings with the complainant, respondent, and witnesses, then the case would be adjudicated. There wouldn't have to be the students wouldn't have to sit in front of a panel to actually have the case be heard, essentially. I think this is a very good thing. because it gives students the chance to actually defend themselves pretty well. Because it's kind of hard to defend yourself if you can't talk to a person besides, if you can only talk to the investigator. And we know how shitty the training is for all these investigators. So a lot of them have biases, unfortunately.
Yeah, basically. I mean, it seems like there should be some kind of standard on what it takes to become an investigator, but I mean, maybe that's just
a lot of times schools, it's what Title IX coordinator. Or one example, there was a school that had like the person in the women's center was the investigator or was on the panel or something. So there were this conflicts of interest.
Right.
See, I'm just starting to read into my ethics textbook for my next class, and this stuff makes me shudder so hard. And I mean, even in that, it's brutal just seeing the things that people will sue over, but let alone what the professionals should be allowed to do or what standards they need to be held up to. There should be some.
Yeah, this is the thing. Imagine if you get charged with a crime, right? Somebody has filed a complaint with police, and you get charged with a crime, and you find out that the officer with whom the charge was filed, the complaint was filed, is the detective that's investigating the case, and he's also the prosecuting attorney that's going to prosecute you, but he's also going to be the judge and the jury. And you're not allowed to face your accuser in a live hearing. You have to go and talk to this person without the benefit of an attorney's assistance or protection, right? You have to just go talk to this prosecuting, judging police officer, detective, and hope that you can argue your case before this person, and they don't convict you, and they don't close their mind to the possibility that you're innocent. That's basically what the old standards allowed students accused of sexual misconduct on university campuses to be subjected to.
Yeah, some single investigator models, instead of the person being the jury, they would provide a report to 3-5 people that they would basically look over the report and adjudicate that, and still no live hearing. The reason that schools would do all this is because it's expensive to have live hearings compared to single investigator models. But I mean, why should schools be investigating this in the first place is a completely different issue, and law enforcement, the judicial system of the United States kind of exists. I don't know.
Yeah, they really
apparently cops don't know how to treat alleged victims with care or anything. But
they
sound like schools do it better.
Yeah, the fact is though that when you've been a crime victim, the cops are very sympathetic. They are also very down to business. They want to make sure they get all of the evidence, because if they want to walk into court and try to prove that somebody committed that crime against you, so that they can, get whatever penalty for that crime the state has handed down to that person, they want to know that they have all their ducks in a row and they're not failing you. And they also have to know that you're not lying to them. But it doesn't take a whole lot for them to figure that out. If you're telling the truth when you walk into a police station and you've been victimized by a violent crime, or even just you've had something stolen from you, your demeanor, everything about what you do when you go in there makes it pretty obvious that you're a crime victim. They're not gonna blow you off because of what type of crime is being investigated. That's a feminist myth. They're full of crap.
Yeah. I mean, geez, like even the one time when this, it's a little awkward, but this woman chased me down for speeding, and then she she super followed me. Like when I first got my license, I did the stupid dumb kid thing and I was speeding, and then she chased me down, and then she's like, "I'm reporting you to the police." And me in my
so she sped to chase you down.
She did, and me in my teenage lawful good nature, I'm like, fuck you, I'm gonna go to the police first and say, hey, this woman reported me, I'm sorry I did
this crazy lady is chasing me.
But yeah, even then they were still very sympathetic to me and were like, thank you for coming to the station. So they're not gonna tell you, oh, clearly we don't care about your crime, because even when I did something wrong and I went and owned up to it, they were still very sympathetic to me for it.
So if you were driving on a highway in New Jersey, yeah, you could go however much of it. Like, what's the speed limit? That's just a suggestion.
Yeah, it is.
Assuming the traffic moves, unless if it's a dead standstill, like it is.
The logic of feminists on the cops just is dumb, in my opinion. You think about this, all right? You imagine for a minute, you decide you want to become a professional baker, okay? And to become a professional baker, and to be taken seriously in the industry. Imagine you had to have a license to become a professional baker, besides the one that you know, the certification that you know how to handle food and you know how not to give everybody salmonella from raw eggs and stuff. But your actual education as a baker. So you get that. You go to school for 4 years. You go into debt. You take out college loans, and you spend 4 years cramming your head full of information about your profession and food safety and everything. And at the end of it all, you find a restaurant or you know, even a grocery store can hire a baker, right? They make donuts, they make bread. Sometimes grocery stores have their own bakery, right? Some of them make cakes, decorators, and yeah. So you get in there. And you now have this job of baking cakes and breads and pies and donuts and anything else you can come up with, right? Customer comes in to order some of your product, and you're like, I don't believe you actually want that cake. I think you're making it up. Prove to me that you wanted that cake. You know, do you want that cake? And
like, do you really want that cake?
Yeah,
the cakes aren't pretending? The cops aren't gonna do any different. They gotta go to school. They have to have a degree. They actually have to go through the police academy. They don't just learn you know, how to properly make an arrest. There's forensic science they have to learn. There are ethics classes they have to take. There's a whole host of stuff, and they have physical training that they have to go through as well. And that's just the education part. They are going into a job where the people that they have to deal with, there's a risk that they may be shot by those people, right? They may have situations where they confront somebody who is accused of a crime, or who they see doing something that looks like they're committing a crime, like they're trying to break into somebody's house or something, and the person may turn around and shoot them. So they don't just go into that profession just to tell people, yeah, I don't believe that you actually came in here to tell us this thing happened to you with bruises all over your face and your clothes ripped, because, you know, it happened. We think that you made this up. That's just not logical. But feminists spend a lot of time convincing women, or at least trying to convince women, that is the primary response a cop is going to have to somebody coming into their police station, to basically activate the entire purpose of their job. Is, you know, oh no, I don't think you want to do that.
Yeah,
it doesn't make any sense. It's like, again, it's another one of these questions where it's like, why do you want to believe that? What are you trying to accomplish by getting people to believe that? What is your goal? Because clearly it's not to help people get justice for what was done to them. Because really, how else are they going to get that?
Yeah. Well, cross-examinations being actually allowed will help
that's true.
Students be able to get justice. That's our next point. So previously, advisors kind of really didn't do anything in the whole Title IX investigation system. Most schools, virtually all of them, the advisors weren't allowed to talk. They were basically allowed to whisper in the student ear, and the students themselves had to represent themselves, essentially. which if there was a live hearing, which a lot of schools didn't even have live hearings, but in the case of live hearing, the advisor just kind of sat there. Now with cross-examinations will allowed to be occurred. However, the advisors will be the ones doing the questioning. And if one of the parties so wishes, the questioning can happen in another room, but it has to be like all happening simultaneously, and both parties have to be able to hear each other so that the panelists can see the responses of the students or any person that happens to be being questioned. That can judge character, because in most of these cases, it's a he said, she said type of scenario, and a lot of the time the only evidence that there is the credibility of the complainant. A lot of criticism has been levied against this particular part because they say, oh, look at all these guys with their rich lawyers coming in to lawyer the complainants into submission, basically.
Oh, God.
So they think that the guy who's accused lawyer will be, I guess, brutal or, be a good lawyer and ask tough questions and stuff like that, which I think they'd be afraid of, because if, again, the only the evidence that comes down to this case, most of these cases, is what the complainant says happened. And if you can poke holes in the complainant's story and say whatever to make them look less credible, good lawyers should do that, but they're afraid that money will basically decide these cases.
No, that's not going to happen. Money doesn't decide cases. The impression that the arguments make and the impression that the plaintiff and the defendant make, that's what generally decides cases. If money decides a case, there was something else going on that it wouldn't have mattered whether the lawyer came in or not.
Right.
But in the case of, or in the situation of being able to see somebody when they testify, this is elementary. Like, this is normal in the court system, that you are
normal in the UK.
Yeah. Oh, it is in the US
case.
And yeah, no, it wasn't normal in the UK.
Yeah, no, the UK is with Mark Pearson and what's her face, Suad Faris, I think.
Yeah,
that's what it was. We're allowed to say her name because we're not British citizens, so we won't get arrested.
That's good. Yeah, because I've said her name a whole bunch of times, so they can come over here and get me if they want to, but there might be some people in the way.
She'll appear in the mirror.
There you go. I'm not that old yet. No, seriously, the importance of being able to see the individual's behavior when they talk about their experience, when they're trying to tell you what happened to them, or their story in any way, it really is. It can't be underemphasized, because you get people who will. You can tell when they are being fake. You get people who will fake tears. You get people who will fake a tiny little girl voice, so they, oh, poor me, and everything. And then
I know who you're referencing with that one.
Yeah. Well, and see, the vexatious litigant case, the reason that when I saw that, I was just like, oh God.
I was thinking of a different one, but okay.
But yeah, Ford.
I was thinking of the Supreme Court.
Yeah, when
nomination.
I saw that, it took me right back to the vexatious litigant case, because that is what the vexatious litigant did. She came in, and this is a woman who is like 5'10", and at least right. She's at least 200 pounds, okay? Her shoulders were as big as my head. I would not have wanted to deal with having this woman mad at me. I probably could have, but I really wouldn't want to. And she comes in, and she does this thing where she hugs her shoulders in, and she hunches her head down, and she puts her elbows right up against her belly, and she puts her, makes fists with her hands, and she puts them over, and it looks like she's intimidated. But she breaks character every so often to glare at the ex And you're not supposed to
Wow.
notice. You're not supposed to notice that she when she glares at the X, her entire demeanor changes, and she leans forward, and her shoulders are out, and her elbows are out, and her fists are white, and everything. And
those will be cut out post-processing.
Yeah. And so that goes on. And I'm like watching this, and I'm going, oh God, that's totally transparent. So then she gets on the stand, and she testifies. And, I mean, she has a higher-pitched, girly voice anyway, but she did that thing of barely opening the mouth when you talk and making sure the last letter of every word is drawn out to become part of the
Breaking
first,
your voice.
Yeah,
Oh God, it just tortures me to hear
vocal
hear people
fry
talk
in the
like
middle of
that.
it and everything. But a person who's actually been through a trauma, I've seen enough people describe their traumas and heard enough people describe, and I've had to do it myself. When you are that traumatized that your manner of speaking changes when you talk about the trauma you've been through, there are visual changes in your demeanor, and they are not they're not like that. You end up literally shaking, and it's not like a whole body shake. Your hands might shake, your voice might shake. When you're doing that and your voice doesn't shake at all, your hands don't shake at all, you break character periodically to glare at your ex. It just, and I mean like aggressively glare at your ex. It totally blows the illusion that you are intimidated and traumatized and all that. And I
Just
like,
sad.
yeah. And I think a better decision comes out of people being able to see that.
Yeah.
And it's not so much that alone would make the decision, but if they just listen to the narrative being read off, or they read it on paper, it's not anywhere near the same. You can use various ways of wording things, passive voice, things like that. Instead of admitting that you took your own pants off, it's my pants were off. And then the person reading has no way of knowing how that happened. And they don't see the way that you look, and they can't tell that you're dodging admitting that you took them off yourself, and they can't ask because you're not there. So yeah, having all of that, having that ability of them to be in the room together, to have questioning done in front of the people that are going to make the decision, to have the visual of the individual being asked those questions and answering those questions and everything. A traumatized person usually wants to tell their stories, right? And a traumatized person, like, they might have a rough time telling their story, but if you ask them a question that gives them the opportunity to provide details of their experience that will help come to a resolution, or bring about some sort of a resolution, they don't get offended that you asked about that detail, unless you openly insinuate something stupid. Then that can be frustrating. But when you've gone through a trauma and somebody says, well, what were you doing right before? What did the person interrupt? What happened next? And they want you to tell how violent the person was or whatever. You don't get offended about that. It can be hard to talk about, but it's not offensive to be asked to describe what bad thing the person did to you. And those are all things that these fakers will give themselves away on.
Well, yeah, because I mean, like, it shouldn't be offensive, because you're trying to give the full story so that the person can get punished. It wouldn't make sense to be offended by that. You would want the story to come out so that something could be done about it.
Yeah. So the next bullet for the big changes is that students have to actually schools have to actually give complainants and respondents any information that comes out, and this is important to the respondents, that specific details of the allegation of wrongdoing, so that they can, and opportunities to review any evidence that's gathered. A lot of schools have hid exculpatory evidence from complainant or respondents, rather. So there's stuff out there proving their innocence, and they don't know that the school has it. Like the student might say, "Hey, go check her phone because I know that she texted so and so or texted me or whatever, and that should exonerate me or whatever." Sometimes schools just don't follow up on that, and they just kind of ignore that. But it'll be interesting to see how schools respond to this.
This is a big one, actually, because exculpatory evidence is evidence that proves that you might be innocent. It's and sometimes there's exculpatory evidence that in and of itself isn't proof of innocence, but it calls into question evidence that is being used to try to prove guilt.
Or a bunch of circumstantial exculpatory evidence that, when you put it all together, paints a much clearer story.
For instance,
seems totally
the points by themselves
bankrupt that they would even want to hide that in the first place.
Well, they fought to hide that in the regular court system.
When schools are afraid of losing funding, right, the 2011 guidance scared the shit out of a bunch of schools that they were going to lose funding, even though not a single school has yet. And there have been crap tons of OCR investigations into schools that have failed complainants.
Well, I mean, like, it doesn't even make sense. Like, why would they lose funding because of what some other student does? Like, if that's not
because they could be found in violation of Title IX and depriving educational opportunities of yada yada yada.
Yeah,
God damn it.
I'm gonna just go over this really briefly. Title IX, again, Title IX has like really overly broadened since it came out. It passed in 72. And the whole goal of Title IX in 72 was you can't have a quota system or a restriction system that says if an area of your school, an educational area, is open to the public, that it's more open to one sex than the other. You can't have sports be more open to one sex than the other. You can't have any like internships, anything like that. You can't discriminate on the basis of gender. In making those available to your students. And over the years, they changed that from the availability standard to equal use, basically. And they started attacking academic areas and athletic areas that women were less interested in. And then they started attacking, like the academic areas, they attacked by trying to force women into them that weren't interested. The athletic areas they attacked by trying to force them out of the education system if women were not as interested in them. And what that ended up resulting in was a lot of schools have dropped their Olympic wrestling and their male gymnastics teams and everything. So there goes, future generations of Olympic stars from the United States. And then they started in with this intimate partner and sexual violence regulations, where they passed the Clery Act, requiring schools to start documenting this stuff and reporting it to the government. And they started making Title IX about access to the university in terms of if a student doesn't feel comfortable or safe there, they don't have access. That was the claim, and that led to all of this. The Dear Colleague letter in 2011 was kind of the culmination of the idea that women, they couldn't complain anymore that women were being kept out of academic areas by quotas. They couldn't complain anymore that women were being kept out of athletics by unequal interest, because schools had done everything they could to accommodate those standards. So now they had to complain that women were being kept out of education by men. And you got to get rid of men on the campus, and that's how they did it. And that's where we are now. That's what we're fighting now.
Yeah, I was reading something earlier today where I think it was the percentage of women participating at in sports or whatever is higher at co-educational institutions than female-only institutions or something like that.
That's actually really interesting.
Yeah, I'll have to find if I can.
I'll bet you'd find
that one.
I bet you'd find a significant number of them were on co-ed teams too, like the track team, because it is fun to participate in a sport where the guys are going to cheer you on too, and there's a sense of sisterhood being on an all-female team. Like when I ran cross country, it was like that. But being on the track team, it was like being part of a big family. And it was, not just the sisterhood, but actually the classmate family. And when I have gone back to class reunions, it's been the other kids that were on the track team with me that were the most excited to see me and the most welcoming, and I was excited to see them and everything. And that's probably a lot of gals are kind of being robbed of that. In terms of, today's universities are cutting down so many sports because of the regulations Title IX has put into place. They basically have to show equal participation, or at least participation proportionate to the percentage of the student body each sex is. And with women outnumbering men now on a lot of campuses, there now have to be more women participating in sports, or the university is open to a lawsuit. It's just it's crazy. But with regard to which point were we on? We were on the point of
information.
The exculpatory evidence. In terms of that, if you really want to see what damage that does, you look at the statistics coming out of the UK and how feminists are trying to use them currently with regard to intimate partner and sexual violence. Because it just came out that the police forces in the UK are being sort of audited and found to have withheld exculpatory evidence in a number of cases. And
there's been a bunch over the past 2 months.
And feminists are trying to claim there's a high rate of sexual victimization of women by men in the UK, and that 95 or 99% of perpetrators are men. Well, if you have police withholding exculpatory evidence when men are charged, then you're going to have more men convicted. And at the other end of it, you have women's organizations in the UK fighting to prevent women who are accused of violent crimes from facing the same standards and the same repercussions as accused men. So then you're going to have a reduction in convictions of women, and you're going to have different labels placed on their convictions and everything. So it becomes really easy to create that statistic, and then you use that statistic to support maintaining those bad methods, and then you end up with a lot of people falsely convicted, a lot of men falsely convicted, and a lot of victims of female perpetrators having no recourse against their perpetrators. Well, the same thing's going to happen on university campuses if they do not allow the student the right to exculpatory evidence, and it can make or break a case. You find out that the accuser has said, well, this action that I took is evidence that I was fighting back, and the accused is able to bring in 10 people that say, oh yeah, I know she does that every time she has sex. It's a sign that she's having a good time, and they can show that they've had encounters with her, and she's texted them afterwards, and it's all normal. Or an accuser says, I've never been in communication with this guy, and then he said this incredibly lewd thing to me and shoved me up against a wall. Come to find out he has a year-long texting history with her. Things like that. Or the situation where, the young man that was accused here in Dayton at Sinclair University of an offense that required him to have 3 hands. If he doesn't get to know the description of the offense, he doesn't have the opportunity to say, now wait, how did I simultaneously pin this woman to the wall that's bigger than me, this woman that's bigger than me, to the wall with one hand, and feel her up with another hand, and masturbate with a third hand? Where is my third hand? Where is it? You know, you got to be able to know the details of your accusation. You got to be able to have the right to all of the evidence that's being presented against you, including potentially exculpatory evidence. You've got to be able to have the opportunity to form arguments against all of it. Yeah.
It's especially scary when, I think I had mentioned this before, during when the lawyers were talking about how to, like, things to do to not get sued. Somebody had asked them about, like, okay, we understand that you're lawyers and all, but you're using this word exculpatory evidence. What does it mean? And when people that are doing the investigations or the adjudications or sitting on panels or whatever their role is within this system don't know what exculpatory evidence means, it's kind of scary. It's a legal term, yes, but you know, you're basically in a quasi-judicial legal system.
Well, and the fact is that
doing that, you got to know what you're working with, obviously.
And it almost indicates that they sort of are presuming guilt from the beginning and do not think that there could be evidence that is exculpatory.
Well, speaking of evidences and what standards for evidence, a big change for this, which you'll be very curious to see what happens, is that the schools, sure, you can use preponderance of evidence standards, but you basically have to, any type of adjudication of academic misconduct or student misconduct or faculty administration proceedings would have to use the same standard. From the sounds of it, most schools with their faculty, they have the clear and convincing applied to them. And then clear and convincing is typically used throughout other academic proceedings as well. But when it comes to the sexual misconduct, schools have the preponderance of evidence when it handles those. So it's basically one or the other. And a few articles I was reading discussing this, saying that a lot of teachers' unions would probably be pissed off if suddenly their standard when they're facing some sort of administrative proceeding went down a notch or two of the standard of evidence that they're held to. So it'll be very curious to see how schools respond to that.
Yeah, and I know exactly the argument they're going to make too. The reason that we have the due process standards specifically for evidence, the beyond a reasonable doubt standard versus the preponderance of evidence standard, and the reason that in more serious cases that carry more serious punishment use the more strict standards is because our forefathers decided that you should not be subject to heavy punishment without solid proof, without meeting serious standards for evidence. So that wasn't just supposed to apply to courts. It was, if you're going to have something major taken away from you, your freedom, a significant amount of your property, a huge fine, things like that, the state's not allowed to just take it away from you without meeting that high standard of evidence, without being as certain as reasonably possible that they're doing it legitimately, that it's justified. And your education, especially if you're going to continue to remain in debt for it, but your education, your potential for your future career is as significant as a jail stint. Having that taken away from you,
it destroys your life.
Yeah, it's as significant as as being put in jail for a number of years, because you can't recover from it any better, any easier, any quicker than you can from that. So this is something that, regardless of people's arguments that just because it's not in a real courtroom doesn't, that somehow means that the standards for evidence should be different.
Hashtag was only a job interview.
Yeah, no, it wasn't only a job interview. It was the biggest job interview of his life. It was a huge life change. It was his reputation throughout the world, not just the country, not just in his legal profession, not just among his friends and family, but the entire world watched this case. Every country that has television, every country that has print media, watched this case, because the United States is just that watched. And something that big, something as big as your potential future, no, that shouldn't be taken away from you without meeting a very serious standard of evidence.
Yeah, absolutely.
So if we have nothing else to discuss on this point, the next point was about how a lot of schools, when fired in a study, I can't remember the percentage of schools, but it was very sub 30%, I think, of like the top schools that they looked at, didn't explicitly presume innocence of the respondent. The new regulations say you must assume that the respondent is innocent of the charges being laid against them.
I mean, it's only one of the basic cornerstones of the legal system in the free world.
It's kind of a thing in the Western civilization, you know.
Yeah, maybe we should respect that a little bit.
Yeah, keep in mind that all the articles that are coming out on the various websites are saying that these rules are going to make it harder for people to make complaints against their whoever victimized them, allegedly. That it's going to make it harder for students to report sexual misconduct or to get justice or whatever. I'm like, presuming innocence?
Yeah. I want to remind everybody, feminists argue that false accusations are no big deal. They argue that being falsely labeled a criminal, even temporarily, is no big deal, because if you are innocent, you have nothing to fear, right? If you are innocent, they argue that if you are innocent, that you would just have to go through the process, and it will carry you out, and it'll all solve
they even
itself,
argue
right?
that you can learn from it,
right?
So you could learn from being
conversation. I want to literally punch anybody in the face.
He says that, right? They argue.
It started a conversation that this guy's life was destroyed by false accusation.
Right. They argue that the accusation itself is harmless unless you're proved to be guilty, and then obviously you must be, and you didn't have something to hide, so you had something to fear. Well, then they turn around and say you're going to be presumed guilty from the start, right? It should be all right for you to be presumed guilty, and it's harder for people to make accusations if you're presumed innocent when they make these accusations. Then if you are innocent, you have nothing to fear, but we're going to presume you guilty, and you have to prove yourself innocent. And while we're at it, we're going to ensure that certain evidence that might prove your innocence isn't allowed in the hearing. You're not allowed to present that as evidence that you're not guilty. So, if you have nothing to hide, then you have nothing to fear doesn't apparently apply to the accuser. And if you're not guilty of lying, then you have nothing to fear from all of the evidence being shown, from due process standards being followed. Apparently that doesn't apply to the accuser either, except it does. And the reason that they are upset, the reason that feminists are so upset about this protection of due process and this protection of the innocent until proven guilty standard, is because they know that there are accusers, there are plenty of accusers that do have something to hide, and that do have something to protect, and that are making false accusations, and that's something for them to hide. They do not want to admit that some of their assertions, like their rape culture narrative, are based on continuing to count false accusations in with legitimate ones. So, of course, they're going to be upset about this.
You're going to continuously cite that 2 to 8%, which came from some judge pulling a number out of his ass however many decades ago, and then some journalist reporting on it, and that's where we get the 2 to 8% number.
Yeah.
It's nutty. Yeah, so we'll see how that one goes.
Yeah,
over.
the idea that if an accuser has to prove her case, that's going to make that's going to come down on rape victims is almost an admission by feminists that most people who make accusations aren't actually rape victims.
Yeah. So up next is another pretty big change, is narrowing the definition of harassment. In 2011, the guidance, it was any unwelcome conduct of a sexual nature. It's pretty freaking broad, isn't it?
Very.
Yeah, you could interpret almost anything to be that if you want to.
Yeah, somebody hit on you and you didn't like it. Basically,
Yeah.
is that, and that has happened where
I
people
find you
have
very
basically hit on somebody in a bar or whatever.
I find you very
or,
interesting. Would you like to go and get a coffee?
Yeah.
Yeah, no, you're sexually harassing me. It's been so the new definition under this proposed regulation is that defines harassment as any unwelcome conduct on the basis of sex that is so severe, pervasive, and objectively offensive that it effectively denies, a person equal access to the recipient's, so that's the university, is when they say recipient, the university's education program or activity. So basically, it has to be really, really fucking bad instead of just, oh crap, you hit on me at a party.
Yeah. The first standard would actually allow someone to make an accusation because they had to sit in class next to a guy wearing a t-shirt with fake cleavage drawn on it. And the latter actually requires there to be something that does interfere, that would meet the standards that Title IX was created to push. Basically, that it would actually interfere with someone's education.
Right. It has
that's
to
a big
be
difference.
so bad.
And it should be that way. If it wouldn't meet the legal definition, you shouldn't be suing for it.
The previous definition was so broad.
Yeah.
I don't understand how they came up with it. Actually, I do. They just wanted to put more guys out of college.
Yeah.
I really feel like the attack on due process is more a way of breaking down the protections that people have against having...
Apparently the stream died.
My OBS is broadcasting very slowly. Yeah, OBS is broadcasting very slowly.
For a hot second.
Yeah, being a temporary asshole.
Yeah, OBS was broadcasting very slowly. Sometimes it does that. You have to just sort of reload the page, and it's just a problem I've seen with OBS. So it's. And at the other end of it is, I think internet on this block in this area kind of gets periodically throttled. I've seen some evidence of that as well. So there's nothing we can do about it, and unless the
F5.
Yeah, unless the stream stops broadcasting altogether and it says it's over, generally I wouldn't worry too much about it. But
we'll just make a Title IX complaint against the internet.
Yeah, it's just the neighborhood I live in is not the neighborhood where lots of people are paying for great internet service, so we are being served by equipment that isn't the best. We'll just leave it at that.
Yeah, I basically have either Comcast or HughesNet, so Comcast is.
Yeah, we can have a few different choices, but the least bad choice out of all of them at this point for us is Spectrum. And like the other choices have actually been worse. We had Time Warner and Spectrum bought them out, so that's where we are. But they bought
press F to pay respects for Hannah's internet.
Well, and it's the more I've looked into it, it's they're not gonna be able to do anything for us where we are now, and we're still working on moving, and we keep having one roadblock thrown up after another. So
oh no.
Yeah. But in any case, since we've had that interruption, I'm gonna catch up on super chats.
Okay.
Let's see. We go all the way back to the beginning. Now, the first one was actually, I think, from yesterday, because I saw it in the super chat box when I was making the stream. So I'm pretty sure this one maybe slipped past another stream and didn't get read. So if I'm reading something that's been read before, sorry guys. But at some point in history, Hokibukisa gave us $4.99 and said, incel began as a self-applied label. Normies appropriated it because they didn't have a succinct word to mean virgin loser, so now it's a smear label. And that's a pretty good description of how that happened. At the beginning of the show...
People are pressing F in chat for your internet, by the way.
Yeah, I see that.
All of the respects.
Yeah, your OBS was streaming. It is streaming. It just goes into the red, and it goes from streaming at almost 4,000K per second to like 100K per second. So or 200, and it dips down like that. Yeah, it dips down like that for a minute, and then it goes back up. And it's my internet. But yeah, Master Rogue gave us $2 and said, Prim! Hug face, heart face, smiley face.
Hi, Rogue.
And Chris Stewart gave us $5 and said, something I meant to say in the No Nut November stream, they do know a number of women participate in No Nut November, right?
Didn't No Nut November start as like just not... it's supposed to basically be laughing at the feminists, I thought.
No Fap.
Like I thought it wasn't a serious thing at first.
No Fap started laughing at feminists. That was yeah. What happened was a bunch of guys on 4chan. Well, it's the same thing as the Piss for Equality.
Oh, 4chan, of course.
Yeah, a bunch of guys on 4chan decided they were gonna come up with a, and the thing that they did that was genius was they created a NoFap group, and then they waited until they got some people riled up with the NoFap group, and then they created an anti-NoFap group. So the same group of guys arguing back and forth with themselves online got a bunch of people all riled up and debating this idea, this NoFap idea, and that led to No Nut November.
Okay.
So,
I knew that it had pretty lolsy start to just.
Yeah, it's in all reality, it's really cringy that anybody took it seriously and made a serious thing out of it. It just it's as bad as like I said, piss for equality and some of the other stupid. And it's easy to get people to believe in stuff like that when you have feminists out there doing art, so-called art, with their period blood. And the one woman who did the performance art where she shoved a ball of yarn up her pooter and knitted with it.
What?
I'm serious.
What?
That actually happened. That was a real thing. She made things out of vaginal fluid soaked yarn. And then she continued. She didn't stop when she was on her period, right? So.
Oh no.
You gotta make the red decoration in the middle of the sweater,
So the Poe, is strong with that movement already, and then you get that stuff just people buy it because, well, what the reality is so fucking nuts.
Absurd.
What's not to be believable? Then, so going on, we have Chris Stewart gave us $2 and said, Hannah, your foot is your third hand. So obviously,
Yeah, apparently.
Obviously, you've seen that old video of me writing with my toes. I actually, it's just I used to be able to do it. I would put the pin between my big toe and the next toe, and I could write my name, I could write hello, you know, I could write a couple of other things. Very agile, I could pick things up with them. Obviously, I'm not going to use them for cooking, but I could do it. So, yeah. I'm part monkey. I'm not as evolved as the rest of you guys. Chris Stewart gave us $10 and said, also from the last stream, I have been circumcised as a child, Hannah. I don't feel violated, even though intellectually I know I should. I support anti-circumcision protesters. I don't hate them. So the first thing is you don't have to necessarily feel violated to know something is wrong.
Yeah, I was gonna say, like, you know, it's very subjective. You don't have to feel violated by something. If you don't, that's fine. But like a lot of people do, and that's, I mean, it's not fine at all. But I mean, it's fine that some people feel violated and some don't, is what I'm getting at. But it's a very individual process.
Yeah, and the thing is, it's this way with people that have been mistreated in other ways as well. In fact, it's really common for people who were groomed, particularly heavily groomed as children and molested, to spend years and years coming to terms with what that person did to me was actually wrong and bad, and they should not have done it. And if they were an adult and not just a kid that was older who had been also victimized, they should have known better. You know, if they were a much older kid and they weren't, you know, brain damaged, they should have known better. That kind of thing. People don't necessarily. It's not easy to condemn the people who were your trusted folks when you were growing up. It's not easy to condemn their actions. They did something wrong. So your parents take you to a doctor and the doctor does something to you. The first thing that you would have to come to terms with in order to feel violated by what was done to you was the fact that your parents trusted the wrong person with your health and safety. And it's not abnormal to trust a doctor with your health and safety. You don't have to condemn your parents for that. That's really the doctor's fault. The doctor should have known that what they were reading was ridiculous and questioned more in terms of what various research said about that procedure. Too many didn't. So, you know, and attitudes about children's rights have evolved significantly over the last century. So you don't have to feel violated to know that it's wrong. And there's nothing wrong with being 100% totally fine with the condition of your body as it is. I'm 100% totally fine with the condition of my body as it is. I have a herniated disc. I have asthma. I have chronic pain. I had to have scar tissue cut off my labia when I was 16 because somebody bit me when I was 12. And I'm not going to go into that story, but yeah, that was a traumatic experience.
I bet.
Ow.
I couldn't talk about it for a long time at all. But in any case, you know, all those things are changes that, you know, if I could have at the time refused those changes, I would have. I would not have allowed myself to be bitten. I wouldn't have allowed myself to have been in the car accidents I've been in. I wouldn't have allowed my coworker to dump a 100-pound woman into my arms by surprise and run, which is how I ended up with the herniated disc. You know, none of that stuff should be happening to people. Yeah. There's not a, you know, this should happen to you thing, right? But you don't have to feel victimized by changes like that to know that, hey, this isn't something we should be promoting. You know, I sure wouldn't advocate that we line all nurses' aides up and have somebody injure their backs because my back was injured and I'm okay with it. You know?
Well, plus too, like, I mean, it's kind of related to what we were talking about last week. The last thing that I think any of us would want to do is to try and push somebody to feel victimized when they don't feel that way about anything that happened to them, right? Like if you're fine with it, then that's totally fine. You don't have to be a victim of anything. Like Hannah said, you can still appreciate that it's a thing that shouldn't happen and that we should like argue against happening in the future. But you don't have to feel like a victim of anything. You can be totally fine with the way it is. No, there's nothing you can do to change it anyway, right? So
yeah, exactly. I would rather help people not feel trapped in victimhood than talk people into feeling victimized.
Yep, victim ideology is not healthy.
And
so
I have a couple more. I wanted to answer Chris Reason. I do remember the episode, but I don't remember what the abuse was. I remember the episode because I was watching that with my parents when I was a kid, and I got kicked out of the room. So they didn't censor my television watching that much, but I actually got kicked out of the room for that on that episode. So I always wanted to go back and watch it again, and I probably will someday. But let's see, we have
French Honey Badger.
Yeah, French Honey Badger's next. He gave us $5 and said, "If you're innocent, you have nothing to fear. Tell that to Lavoy Finicum. Oh wait, he was shot. You can't. You can't. There's a whole lot of people out there that you can't tell that to because of what was done to them after they were accused.
Yeah.
And that's another good argument for if you have there are people who've been beaten to death by mobs because they were falsely accused. So yeah, no, you always have something to fear being accused. Catherine Scully gave us $5 Canadian and said, "I am not a gynecologist, but that cannot be good for your VJ." No, it's there's bacteria in your
mouth. Shoving stuff up there is not a good idea.
No. Well, okay. I thought she was responding to my pointing out that I'd been bitten. There's bacteria in your mouth that you don't want anywhere else.
She did that before you started talking about that. That's when you were talking about the ball of yarn.
Oh God, no. There's bacteria on everything that you don't want inside you. Like ball of yarn is probably pretty filthy, actually, especially after sitting in the warehouse and then sitting in the craft store and being picked up and handled by everybody that considers buying it and then put back.
Snotty-nosed children.
Yeah, if you don't wash that yarn before you put it in there, you're begging for an infection. Chris Stewart gave us $5 and said, "Holy shit, Hannah, I thought I was the only surgery monkey here. 2 open heart surgeries, 2 spinal corrections, 3 eye surgeries, ankle surgery." That's a lot more than I've had. I'm like, you have to be like the toughest person in chat right now. Because I've seen people through surgeries and that's rough.
Hardcore.
Yeah. And I've been real fortunate. I've been able to live with the back problem. That happened in 94 or 95. So it's been a long time. I've been able to do all right. Sometimes it hurts, but really bad. But I still am able to I'm working and everything. So I think you have trumped me in terms of what you're dealing with, what you're toughing out versus what I'm toughing out. So, but anyway, that is all of our super chats so far. So we can go on to the next item, and I think that one. How many do we have left?
2.
Okay, we'll just do the next 2 then, and then we'll get through this in one show.
Nice.
Yay! So next up is any title violation. Basically, must be reported to an official with authority to take corrective action. So that basically means an actual person in the Title IX office at the school, not your biology teacher. In order for a school to be found, quote, having known about the incident. So basically, it's a lot harder to put the blame on schools for stuff that they couldn't possibly have known about if the Title IX person couldn't open an investigation or anything. A part of this The incident must have taken place, quote, within the school's own program or activity. So basically, two students having sex or whatever, and the girl accuses the guy, and they were at some off-campus apartment, like half hour away from the school or something.
Like somebody's party.
Yeah, right. If the house or whatever or apartment wasn't owned by a campus fraternity, for instance, or sorority, it would most likely fall outside of the scope of that, and the school wouldn't have to take corrective action. Still unsure whether they would be able to step in, because it involves student misconduct on student-on-student misconduct, rather. So there's been a lot of talk about that particular one and how it's going to be interpreted. Yeah, but schools are going to be not as screwed if there's something that they couldn't have possibly been known about.
That actually goes along with standards that the public school system had used to at least exercise. When I was in school, if you got into a fight with another student, and it happened on the way to school, on the way home from school, or on the school campus, at the elementary school or at the high school or whatever, the school was responsible for handling the discipline process. If it happened after you had arrived home and or before you left home to go to school, and it was off school campus, so like you get out of school, you go home, you get home at 3 o'clock. At 3:15 you go to the park down the street from your house, and you get into a fight with another kid who has come home, changed clothes, and gone to the park too. The school's not responsible for that. But if the bell rings and you go running out the door and you see a student you're mad at and you tackle him and start pounding him into the sidewalk, the school is responsible for the discipline process after that. And that was the way it was handled for years and years. Which is why, my classmates at my elementary school used to actually schedule their fights so that they didn't get in trouble at school for getting into fights. And, of course, anything that the school's not responsible for is a police matter, and the police aren't going to really do much of anything about two 10-year-olds that duked it out at the local park, and then when it was over they played football together because the fight was done. So that's actually not an abnormal or unusual standard. That's more the norm. They're taking it back to the norm, and it's really a good dividing line, because it especially with grown adults going to university as opposed to students, it would make the school the custodial caregiver for these students that are grown adults 24/7. Right? And if you're 19 years old, you're a 19-year-old male, you can be drafted. You have to sign up for selective service to even get your school loans. You can be, you have the right to vote if you're either sex. You can get a job, and nobody has to ask your parents' permission to hire you. You can sign up for debt, and nobody has to ask your parents' permission to loan it to you. So your school really shouldn't be the arbiter of what you can and can't do when you are not on the university campus, just because you are in residence there and you are attending classes there. They're not your parents, and they're not.
Doesn't make any sense.
They're not a community, as in like a town with a mayor and a city council and a police department. They're a community, as in a school with teachers and students, and that's it.
Yep. So I'd be very curious to see how schools handle that one. And then the final point was what we spent a little bit of time talking about at the beginning, was that complainants and respondents can appeal a ruling. Double jeopardy.
It just seems like, with with rules like that. Like, it could just go on forever until somebody gets a result that they like.
Well,
they only get one appeal, though, right?
Appeal.
Yeah, of course. But...
yeah, they only get one appeal. But the fact that somebody makes a complaint and then their complaint fails or whatever, and then they get to appeal that, it's like, you're kind of making the respondent go through all of that again.
Well, and I mean, like, what are you going to do in order to change the outcome? Like, are you gonna come up with some new evidence all of a sudden? Like,
well, sometimes that happens, but a lot of times when it comes to appeals and such, it's pointing out logical flaws. So typically they'll, or with these rules at least, new rules, that complaints and respondents should actually get full reports of the findings by the adjudication committee. So you would respond to be like, hey, they drew some sort of false conclusion from a bunch of evidence and they outlined it in this part of the report or whatever. You could appeal on those grounds, or there's some sort of procedural error or something like that. It's not necessarily a whole new trial, essentially.
Yeah. But the thing is,
it's not a brand. It's not like a necessarily a rehashing. It's supposed to be focused on like those types of errors, but
right.
A lot of times their appealings are just hearings rehashed.
Well, what it does that's really bad is it treats like the reason that we consider sexual misconduct to be something that should be adjudicated by somebody other than the people that were involved in the act is because it's a boundary violation, right? It's actually an act that would qualify as a criminal act. You are trespassing against another person's autonomy over their body and over their experiences. So
it's not like you cheated on an exam or something,
right? So what they're doing is they're asking for it to be adjudicated as a civil matter, and that's blurring the two areas of law. And civil law and criminal law are supposed to be completely separate for a reason. In criminal law, everything that the court does to you if you are found guilty of violating the criminal laws, you committed a crime not just against the person but against society, and you are being punished for that crime by society for violating the rules that are in place to ensure a mostly safe and civil society that keeps things running smoothly, so we're not stuck in the portrayal of the Wild West where people are running around shooting each other because they're angry, right? Or they have disagreements over something. Whereas with civil law, it's a conflict of either interests or interpretations of an agreement or disagreement between two parties, and the court is just deciding which party is right or wrong. And it's not so much always about punishment as it is about saying who's right or wrong. And it's basically just the court saying, yeah, no, you screwed up, they're right, you do owe them what the contract says or whatever. And if somebody was unfairly dealing with you, then the court might hand down a punishment, but it's still specifically on direct behalf only of the person that you wronged. It's not about necessarily punishing you for breaking society's rules. It's you were unfair and we're going to right this unfairness. So basically, they're in trying to have civil court standards applied to a matter that's normally a criminal court matter. They're trying to blur the line between we're doing this on behalf of society, and we're getting we're engaging in reparations or retribution on behalf of this one person who you wronged. And that's kind of, it gives away the attitude, right, that feminists have towards sexual violence. That essentially they consider it sexual violence against a woman if the woman feels that the guy that she's had sex with or had some sort of sexual engagement with treated her wrong or unfairly.
Mm-hmm.
I don't know if that makes sense.
Mm-hmm.
Yeah.
I just can't help but think about like that the guy could face triple jeopardy if he could go through the process of the school appeal or like the complainant appeals or whatever, and then he's found innocent or whatever, and then the criminal matters comes in because then the respondent or the complainant's like, "Hey, I'm just gonna fuck it, I'm going to the police now after the school didn't do anything."
Yeah.
And then, it's like. And then, like, where it should have gone to the courts or the police in the first place.
Yeah, exactly.
Because those people actually know how to investigate.
Well, feminists really say they don't, though.
Yeah, it's really inappropriate that the schools are doing this to begin with. It just shouldn't be a thing that happens, period.
Right.
Let's all stick to what we're good at.
It's one thing, like, school is all right to have rules and to have a system for handling those rules. What's really wrong is for the state to be mandating that the schools do this. And, a student shouldn't have to guess what's going to happen when they go to school. They should be able to, have some sort of written agreement with the school, and they should be able to choose if they want to go to a school or not based on what written agreements the school is offering. And, I'm not against schools having the legal right to have these systems in place for their schools. I'm against schools having the legal responsibility to have these systems in place. And I'm against them being unaccountable if they handle these systems poorly and they use these systems to discriminate against either sex. They should be accountable for that, and they should not be treated like they are accountable for the experiences of one sex because they chose not to have a system like this in place. That's unfair, and it's unfair to both sexes. But that's just my position. The government shouldn't be telling them what to do. The only thing that people should be asking of them is that they be open and honest about what they're doing, so that when you decide, I wanna become a computer programmer, there's these 30 schools in my area that offer this. Which one do I want to go to? And that can be one of the factors on which you make your decision.
But if also a thing I can't help but think about, if 1 in 4 or 1 in 3 women are getting raped on college campuses, it's worse than war-torn countries.
Yeah.
Is it 1 in 3?
The fuck are parents sending their kids there?
Yeah, exactly.
Like,
that number just seems to keep getting smaller.
Pretty soon it'll be 27 out of 3.
Yeah, exactly.
and they won't start themselves yet with the mental gymnastics.
Yeah, and they won't acknowledge that that's 9 out of 1 because they can't do math. But
that's all I have.
Yeah, I don't know. Do you have any last thoughts on it, Prim?
No, I don't think so. I think we covered everything pretty well this time around.
Yeah, I think we did as well. So I think that's going to be it. I think I haven't decided yet what our next show is going to be about. So, but yeah, I wanted to keep it open just in case, because sometimes we get on stuff like this and we can talk about it for hours. But we won't really know anything until these proposals are adopted or not adopted. My last thought on this is that the feminist temper tantrum over this is extremely telling. I don't give them the benefit of doubt anymore. It's there's only so much, I'm running out of benefit of the doubt quite a bit. And with respect to this, what I said in the opener at the beginning of the show about a totalitarian, authoritarian ideology wanting to take over and dominate and run the country, this is systematic. It's not just haphazard. Now, with the grassroots gets riled up, and their end of it's haphazard, that can sort of fly back in the face of the academics and the leadership of feminists. But I don't think the behavior itself, the slow and increasingly rapid chipping away at due process rights, those attacks on due process rights, I don't think those are accidental. I don't think they're only targeted to just men. I think the goal is to eliminate the citizens' ability to defend against government abuses using their due process rights. And I see this as sort of they're doing this with more than one civil right. Feminists are attacking free speech too. They're using men are abusive, verbally abusive to women. They're using, women don't have free speech if men can contradict what they say. That idea that you don't have free speech if people don't accept your word as gospel. And if you have to deal with counter evidence to the things you say, they're using that to attack the ability to criticize government entities and government actions and initiatives, political entities and political actions and initiatives. That's very dangerous. And they're using toxic masculinity as a narrative to attack your right to have weapons to defend yourself against authoritarian power. So, to me, I see this as essentially an attempt to eliminate your civil rights ahead of an attempt to dominate the country as an authoritarian power. And yeah, that's one of the reasons why I take this so seriously, and one of the reasons why I don't accept the idea that, oh well, it's just university, oh well, it's just a job interview, this isn't important. No, it's vital. It is absolutely vital. We are in a fight for our country and our lives as we know them. And so pay attention. And hopefully, I've scared the shit out of all of you. And with that, I'm going to thank everybody for listening. And, even to my interesting conspiracy theory, which may be right or it may be wrong, but I'm pretty sure it's right. Thanks, guys, for co-hosting the show. And thanks to everybody who helped to make HBR Talk happen in the background. We have quite a bit of people who work on the shows and everything in the background. And good night, all.